From supplementary causes 1 for pronouncement of judgment.
Lead out to the operative part. The Apex Court, in the case of Professor P.K. Vijay Sarathi, observed that where the ingredients required to constitute a criminal offence are not made out from the bare reading of the complaint, the continuation of the criminal proceeding will constitute an abuse of process of the court. In the present case, as has been observed in the foregoing paragraphs, the allegation in the FIR do not constitute the ingredients necessary for the offence under Section 420, 468, 471 IPC. In absence of ingredients necessary to constitute a criminal offence, continuation of the investigation on the basis of the impugned FIR dated 14/2023 will result in abuse of process of law. In view of the discussion made above, the criminal petition succeeds. The FIR dated 14/3/2023 in Tura PS case number 23/3 of 2023 stands quashed. Petition allowed.
Much obliged.
Deeply obliged, Your Lordship.
Mr. Pascal, you have filed your objection. You said you have not filed your objection. Your objection is there in the board.
Your Lordship, in this matter, I had filed my objection, Your Lordship.
But then
There are two
the
connecting
day of the
matters.
hearing, you
Lordship.
said there was no objection. Anyway, it's okay.
Those were the connecting matters, Your Lordship.
It's all
Not this matter.
All right.
Connected matters.
Any mention?
May I please, Your Lordship?
Yes.
I'd like to mention item number 25, Lordship. Due to personal difficulties, Lordship, up to 2 weeks,
Just a
Lordship.
minute. Just a minute. Yes.
No objection.
25 on prayer meeting. List after 3 weeks.
Okay, Lordship.
Yes.
Highly blessed, Lordship.
May I please, Your Lordship?
Yes.
I beg to mention item number 12 and 13, Your Lordship.
12, 13.
Yes.
Pray for 2 weeks' time, Your Lordship.
13 I have no objection because connected matters pending before DB, Your Lordship.
Connected matter means with regard to POXO.
Yes, Your Lordship.
This has not been disposed of till now.
Not yet.
This court was informed that that matter was taken up yesterday.
Yesterday, yes.
So
but
it has
was
not been
complete.
concluded.
No.
12, 13 also on the request made with the petition. List after 3 weeks.
Yes. Highly blessed.
Hello, Lordship. May I please, Your Lordship? I beg to
Yes.
mention item number 10. May this matter come up after 2 weeks, Your Lordship?
Who is the other side?
No objection, Your Lordship.
Lordship, I want to apprise this court, Lordship, that we have instruction not to appear in this case, Lordship, for respondent number 4. Kindly,
No, that is, I don't think any order has been passed for ex parte proceeding, isn't it? Is there any order? No.
No, Your Lordship.
Then you enter your pens, file your power.
Lordship, we are there, Lordship, for respondent number 4. So we have an instruction not to appear in this case.
He wants
Not
to
to
withdraw,
He
Your
wants to
Lordship.
withdraw.
Okay. So what is to be done then?
So, Lordship, what I'm praying is that kindly strike
You
off
have the
our-
instruction not to appear here.
Yes, Lordship.
So what shall we do? We cannot just again issue notice to the respondent number 4. Yes, Mr. Sheikh.
Yes, he is not interested, Lordship, because in fact, in the earlier occasion also, we tried to inform the court, Lordship, because I have the instruction not to appear in this court, Lordship, because he is not interested to pursue.
For that, there is a remedy, Your Lordship.
Yes.
For that, there is a remedy, because I could understand from the submission that he does not want to pursue or prosecute the case.
But then here the submission is that they have been asked to withdraw from the thing.
withdraw as
They have been
counsel. Yes.
disengaged.
Disengaged.
So that is the main thing.
The notice will have to go, Your Lordship.
Yes, Lordship.
No, but then is it the duty of the court to issue notice again and again? Once the
Lordship,
clients instruct them, then client has the notice of pendency of this case. It is not that a new case is filed. Anyway, we'll just say,
Simply adjourn it, Your Lordship.
S.A. Sheikh, Learned Counsel, appearing for the response number 4, submits that he has been, his appointment has been, he has been disengaged.
He is the informant.
Informant is SDS.
Have you returned the brief, Mr.?
My lord?
Have you returned the brief?
No, my lord, I'll return. Once my name is struck off, I'll return the brief.
No, there is no question of striking off. If the party come and takes back a brief, then thereafter you can strike off. But then once, so long you have not returned, means...
I was told that not to appear, lordship, that is why.
Okay. Just do not say he has been dismissed. Say, Mr. So-and-so, Learned Counsel, appearing as the submits that he has received instruction not to appear on behalf of the said respondent anymore in this matter. In view of the submission made, the matter stands adjourned.
Adjourn. 3 weeks, Your Lordship.
To enable the resolution number 4 to engage new counsel in the matter. Stop as paid for by the parties. List after 3 weeks.
Let be 3 weeks.
Okay.
Apply, Your Lordship.
Please, Your Lordship, I beg to mention item number 11, Your Lordship. Applying for 2 weeks. Yes.
Yes. Your prayer has been made by him.
No, Lordship. Yes, yes, Lordship.
Otherwise, you were ready to take up.
Yes, yes, Lordship.
Okay. On prayer made on behalf of so and so. Let's just matter after 3 weeks.
Yes.
Yes.
All right. All right.
May please, Your Lordship. Lordship, I
Yes.
beg to mention item 5.
Item 5. Item 5, you are not ready.
Lordship.
You are ready with item 11 only.
No, Your Lordship, in this matter, we have to file an application, Your Lordship.
Item 5, what happened?
Lordship, we have to file the undertaking. No objection, Your
This is
Lordship.
pending for quite a long time.
Lordship, on the last occasion, the client have sent the signed copy, but they have signed only on one side.
No, if your clients are not interested, then we'll dismiss. We'll say that we'll dismiss it for non-prosecution.
Lordship, one more opportunity may be granted, Your Lordship.
Yes.
Lordship, the application has been left seeks many dates for filing of the application, Your Lordship.
And we'll see what happens. We'll give him one more chance, and then we'll just see. Okay. Prayer made on behalf of the petitioner, not objected to by the Learned Counsel, appearing for the respondents. This is matter after 3 weeks. You just make sure that next time it's not adjourned. Yes.
Highly obliged, Lordship.
Yeah.
May I please, Lordship. Lordship, I beg to mention item number 7.
Item 7.
7, 8, 9 are connected matter, Lordship.
Yes. You are appearing for?
I'm for respondent number 5 and 6.
Yes. What is to be done?
Lordship, it may be taken up after 2 weeks, Lordship, I feel.
It will be after 3 weeks, Your Lordship.
No objection. On prayer made.
After 3 weeks, Your Lordship.
You are appearing all the matters.
I'm appearing in item number 9 for the petition.
I'm for the 7 and 8, ma'am.
So you are appearing for the respondent all the matters.
No, Lordship, and 7 and 9.
Then who is appearing in 8?
You are there, no?
8.
You are there.
For 9. I'm for 7 and 8.
The parties are not same. The area of
These are different parties, but matters are the same. Analogous.
Mr. Shiv.
anyway, then 7 and 9 you just say on prayer made on behalf of the respondent number so and so, not objected to by the Learned Counsel of the petitioner. List is matter after 3 weeks.
It will be 3 weeks, Your Lordship.
Yes. And on 8
He also let come along.
But who are the parties in it?
Yeah, I'm for the
Because
petitioner.
these are related, Your Lordship, analogous, almost analogous.
So it also will list it.
Lordship, yes.
8 you just on prayer made by petition and list after 3 weeks. Yes.
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 Much obliged.
Apply, Your Lordship.
Your Lordship, similar prayer for item number 14. I've taken consent from the petitioner, Lordship.
Yes. There is, you are appearing for respondent number?
Respondent number 1,
And who are appearing for other respondents?
proceeding expert, Your Lordship.
They have not entered appearance, the other respondents.
No, Your
Say, on prayer made on behalf of the respondent number. You have any objection to the
No, Your Honor.
prayer made on behalf of the respondent number so and so? List after 3 weeks. What? Yes.
Highly obliged.
Daily list item number 1.
Yes.
Order passed by the learned First Appellate Court, my lord. Whereby, my lord, the learned trial court, my lord, the judgment in order 17/6/2025 passed in FAO number 1 of 2019. My lord, whereby the learned trial court, my lord, rejected my application.
Yes, yes, yes. Yes.
Let's limited issue here. What had happened is there are two suits, Millets. One is a suit filed by them in 2011, where I was originally not a party. I'll just give the Millets suit numbers. The first suit is filed in 2021, Millets. That's called title suit number 5 of, it's title suit number 5 of 2011. That's filed by them against, some 3 other persons.
You are not the party.
I am not a party originally. Then, my lords, in 2018, I filed title suit number 4T of 2018
Against the respondents.
against the respondent. So, my lords, they enter appearance.
What happened to the other
That suit is proceeding, my
defendants?
lords. Proceeding.
No, they are not party in your suit.
No, my lords. So, then what happens is, my lords, they file an application saying that, my lords, that my predecessor in interest is a party in that earlier suit. So, therefore, I should be impleaded as a party respondent in their suit.
In the previous suit.
Yes,
In
ma'am.
TS number 5 of.
5 of 11, in the 2011 suit. I'll refer to as 2011 and 18
Now
suit.
we are dealing with which T suit?
Well, it's 2018 suit.
Okay.
So then what happens, Millets, that in the meantime, in 2018, Millets, there is an ex parte injunction against them in my suit, in the second suit. Spate of litigation happens, Millets, repeatedly both
What
parties.
happened? You have been impleaded in the first suit.
First suit, Millets.
It was before this interim order was passed in your suit.
After that, Millets. After that. In my suit, Millets, till today, they have not filed a written statement. Number 2, Millets, the injunction is made absolute. They come before this court challenging that order, Millets, some litigation happens. Since the remedy is before a first appellate court, Millets, this court says you go back to the first appellate court. Now, in the appeal, Millets, for the first time, they take a plea that both these suits are the same in respect of the same property vis-a-vis between the same parties, and therefore, Millets, the second suit should not proceed. That's the sum and substance of the matter. The other undisputed fact is no application under section 10 has been filed by them before the learned trial court. So the learned first appellate court, Millets, then takes it upon itself to say that whether, Millets, these two suits are similar in respect of the same subject matter without any materials being before it, because Lordships will kindly appreciate that it is an appeal against an injunction order. Neither is the plaint of the suit available before it, nor is the records of the other suit available before it. The learned trial court therefore frames an issue, Millets, that whether suo motu in exercise of powers under 151, I can stay this suit.
The appellate court.
Yes, Millets. I'll take your Lordships to the findings. The appellate court notes that there is no application under section 10.
without there being any pleadings to that effect.
There is nothing on record. Because your lordship will kindly appreciate it is an appeal under, well, it's against an order of injunction being made absolute. So the learned first appellate court, well, it's thereafter and goes on this exercise and says, no, I have the power because it is under the same judgeship, and therefore, my lords, I am staying the suit. That's the subject matter of the
Your
impugned
suit
order.
was stayed.
I'm sorry, my lords.
Your suit was stayed.
Stayed. So, my lords, in my humble submission, two issues come up. First is, my lords, whether the first appellate court is vested with the power in exercise of powers under 151 to, well, it's exercise powers in respect of which the suit itself makes, well, it's the code itself makes provisions. The law is well settled, your lordships are aware. I'll place the law. The other aspect is, my lords, in the absence of materials before the first appellate court, whether the first appellate court could have undertaken this exercise. So these are the two issues, my lords, on which the impugned order is
Improper
challenged.
exercise of jurisdiction.
My lords.
Finding recorded without any materials on record.
Well, it's because the first appellate court frames an issue that yes, you have not filed, but whether suo moto I can do it or not. And he says, I have the power suo moto, so I am under 151, I am doing it.
Yes, Mr. Karim.
What I would suggest, because in the appeal which was filed by me against the injunction which was made absolute, I have not been able to file my WS as well as show cause. Prior to me filing that, the injunction order was made absolute, my lord. Against that order, I had gone to the appellate court, my lord. So what I would suggest, my lord, if the matter can be remanded back, then the appeal can be...
Remand, but then we'll interfere with the appellate court order.
My lord.
That order has to go, my lord. It is express illegal.
Then if you have that consensus, we'll interfere with the appellate court order, matter will send back, and then they will have the liberty to challenge that injunction. Since they did not get any opportunity, they can raise the issue before the trial court.
Well, it's, my humble submission would be that liberty may not come from this honorable court. Because that would, my lords, then mean that your lordships have condoned whatever their actions is. The other fact is that there were repeated chances given to them to file the show cause and the written statement, which they have not done. They will exercise the remedy, my lords. The remedy, my lords, I am not here to advise my learned friend. My learned friend is well aware what he ought to have done. He chooses only to, my lords, challenge the injunction order on the ground that I have not been heard.
Now the thing is that the injunction order has been made absolute.
My lords.
Now whether if matter is remanded at this stage, whether he will have any remedy open there in the trial court, once it is made absolute.
That have to go, my lord.
Well, it's, the first appellate court can
trying to balance.
I am only saying.
Trying to
Well,
balance.
I am only saying, insofar as the first appellate, your lordship will remand back the appeal. The appeal may be heard within the parameters of the appeal.
That can be done, my lord.
Only within the parameters of the appeal.
What is the parameter of law? That is the main question.
Well, it's
definitely. You see, the parameter of law, according to you, can be one thing. According to him,
no. I am saying, well, it's the parameters of the appeal. The parameters of the appeal cannot be, expanded to, go into questions of section 10.
That is where you see the exercise of jurisdiction comes.
Lordship.
The proper exercise and improper exercise is distinguished there only.
Lordships.
So we'll interfere and we'll just send it back then.
My lord.
Okay. Heard. Mr. Kapil, appearing for the petitioner, and also Mr. Karim, Learned Counsel appearing for. There is only one respondent.
My lord.
One sole respondent.
Stop. Challenge made in this paragraph. Challenge made in this revision application. Is against judgment and order dated 17/6/2025, passed in FAO number 1 of 2019 by the Court of District and Session Judge, Clariot, East Jointel District, Meghalaya. By which order dated 18/2/2019, passed in Miss Case number 3 of 2018, arising out of title suit number 40 of 2018, of the learned Assistant Deputy Commissioner, Cleariot, was vacated. Yes, was vacated. Stop. The paragraph, the contention raised by the senior counsel before this court is that the learned appellate court traveled beyond the prayer made in the appeal and also that the appellate court has exceeded limits of his jurisdiction by deciding the appeal on the points which were not raised by the respondents herein before the appellate court. He submits the impugn order. He therefore submits that the impugn order is not based on any materials on record and hence not tenable in the eye of court, in the eye of law, not tenable in the eye of law. He therefore prays that the impugn order may be set aside and matter may be sent back to the appellate court for reconsideration. Stop. Paragraph. So next paragraph. The learned counsel appearing for the respondent in his usual fairness submitted that the entire matter can be remanded back for reconsideration by the trial court. By keeping all the issues open for adjudication. Stuff. paragraph. In view of the submissions made by the made on behalf of the rival parties, is a submission made on behalf of the rival parties. It is a revision petition is disposed of by setting aside the impugned judgment and order dated 17/6/2025, passed in FAO number 1 of 2019. Stop. The matter is remitted back to the court of the district judge Clariot for reconsideration of the appeal, strictly in accordance with law.
Plus, the question of maintainability of the appeal itself also may kindly be kept open.
I've always said everything is open, left open.
Yes, it is made clear. But then it is made clear. All the issues are kept open.
Well, it's including maintainability, Milits, that if it just falls
All
because
the issues, including the question of maintainability of the appeal, if raised by the contesting parties, shall remain open for adjudication by the appellate court.
Yes. Highly obliged.
With the above, this revision petition stands.
Highly obliged.
There may be some correction here. There, see,
But-
we miss many things in the courtroom. So.
Highly obliged.
Item number 2.
Please, Lordship. Sometimes required, Lordship, for our rejoinder. Sometimes required for filing our rejoinder, Lordship.
Okay.
Just 2 weeks' time may be agreement, Lordship.
No objection. Yes. Okay. Prayer made by Mr. Karkan, Learned Counsel, for the petitioner. Further 2 weeks' time is granted for filing rejoinder affidavit.
Obliged.
Rejoinder against the affidavit of
Respondent number 3, Lordship. Private respondent. 2, Lordship.
Be kind, please. This one.
Item number 3.
Lordship, I have taken step to the private respondent on 4th of November, Lordship. Service report is awaited, Lordship.
You have taken steps on 4th of November.
Yes, Lordship.
What to do?
My Lord.
You ascertain?
Yes, Lordship.
You have taken steps through postal services.
Postal service, Lordship.
Mr. Sheikh, learned counsel appearing for the
2 weeks,
petition.
Lordship.
Wait. Mr. Sheikh, learned counsel appearing for the petitioner submits that the notice has been issued upon the respondent number 2. Stop. However, the related office note indicates that service report from the respondent number 2 has not yet been received. Paragraph. Petitioner shall verify the status of service and petitioners shall verify the status and file a service affidavit in respect of the respondent number 2. Stop. List after 2 weeks.
From supplementary list hearing, item number 1.
We have to supply a copy of the judgments, my lord.
Is it?
So, my
This
lord,
hearing is concluded here.
yes, my lord. Yes, concluded.
And what about the written notes of argument?
That also we have filed, my lord.
Where is that?
That was filed quite some time back, my lord.
Okay. Let us just see. Mr. Devnath. Your written notes of argument? You have
Yes, my lord. We have submitted.
the state respondents. Yes, Ms. Iwanian, advocate. You have also submitted your.
Yes, Your Lordship.
Okay. Wait. When did you file it?
Alright.
No, the petitioner.
On the 6th of June.
6th of June.
Just written on.
Wait,
She's talking about written synopsis, my lord.
See, there appears to be two. One is submitted long back, 2024.
Written synopsis was submitted.
And 6th of June of 2025. So that is what is to be reckoned. The previous one to be ignored. Not very sure.
That will be the latest, my lord.
You cannot make submission on behalf of the other. Please allow them to respond.
My lord.
So you cannot say whether it should be ignored or not. You want the court to consider both the. Okay, we'll do that. There is no problem with that. Have you cited any decision? No.
Yes, they have cited one decision, my lord.
And that is
That was
reflected, that is reflected in their.
No, this was in fact given recently, my lord. So none of our written submissions have
No,
any.
but then what is the decision which they have relied upon? And where is that?
This one, 1998, volume 8, SCC 194.
They have submitted a list before this honorable court, my lord, list of cases. So only one case has been cited. Now this is not, of course, none of these citations are included in any of our written submissions, my lord.
In my written argument, I have separated this. First one I have given. And in the bullet point, I didn't give anything. I record this one.
My lord, we gave our submissions, written submissions 1, and my lord, this is list of judgments that we are relying, my lord. So we've given submitted two before this honorable court, my lord.
No, you have given a written submission as well as a separate list of books.
Yes,
isn't
my
it?
lord. Yes.
That is there.
Yes.
But then, so far as the citation cited on behalf of the petitioner, where is that? There is no indication here. Yes, what is the decision you have cited, madam?
You see, they mentioned this one 1998.
Where
SCC 190.
where it is?
Just give it to the court.
From where you are reading? Where it is?
You see, they have given this one slip and then in this.
They have given just now. So you just give the thing list to us.
Sign and you write the date.
You mentioned the paragraph which you are relying.
Yes, Your Lordship.
Today is 26.
Give that list.
You have
Book
a
is
copy
not
of the
there.
judgment.
Yes,
You have a copy of the judgment.
Just inform the court which court.
Which para are you relying?
What about Mr. Devnath? You have cited any decision?
I have cited and I have given the first case.
You have given the.
When I have given this list of argument, that time I have given.
Where is the list of argument? There is one gist of argument or bullet points.
Not bullet point, gist of argument. In the bullet point,
One is bullet point, another is gist of argument. What is meant by that?
first of all, you give this gist of submission.
This is a problem, you know. You should
This I have given
give us one. You see, you should submit one set of argument.
I am relying on this gist of argument 26 to 24, based on which we argued the whole.
No, that is okay. But then any citation you have given?
Yes, on this side.
What is the citation?
Citation to
It is I given 3 citations.
you just mentioned. The list of citations.
It is page 63.
Page 63 of?
Page 63 of my gist of argument.
Where is that page? Document. There is 2011 3 SCC 436. Is, and what is the paragraph you are relying? Where?
Paragraph 36, 37, 38, 56 and 69.
Where it is mentioned?
I mentioned in
Serial number 26.
Serial number 26, sir.
The index.
Okay, the learned counsel for the parties have submitted their respective written notes of argument and also the authorities cited in support of their argument. Stop. The hearing, the hearing is concluded. Judgment for reserve. Reserve for judgment. The hearing concluded. Reserve for judgment, not judgment for reserve. Yes. Send it to my thing. There are 2 matters, 2 writ petitions, isn't it?
Take together, my lord.
Yes. Call next.
Item from main list, item number 6.
For respondent 1, 2 and 3, Lordship.
No one for the petitioners.
I don't see, Lordship.
On the last occasion also there was no appearance. What is the matter about?
It's a boundary dispute of the two aking.
And who is the counsel representing the petitioner?
Mr. GM, thank you, I think, Lordship. Sir Jonathan.
Yes, at least somebody should be there. On the last occasion also there was no appearance.
Lordship, yes.
Somebody should stand up and mention. And we'll dismiss. Yes, none appears for the petitioner. Let us see if he's on leave or not, Mr.
Mr. GM, thank you.
Oh, Mr. James, thank you. Are you sure Mr. James thank you is appearing in this matter?
I think he's on sunset leave.
This is okay, but then is it that he's appearing? He's
They had appeared on 6/6/25 and somewhere in the month of June, Lordship.
okay. None appears for the petitioner. It is reported that Mr. Jayan Thampiu Learned Counsel. It is informed that Mr. Jayan Thampiu Learned Counsel for the petitioner is on leave. So we'll adjourn.
Lordship.
We'll go after vacation.
Lordship, please.
Lordship, I'm appearing for respondent 4.
Yes. Okay. Then paragraph 1 prayer made on behalf of the respondent. This is matter after 3 weeks.
Lordship, obliged.
Item number 15.
Yes, Mr. Jinder.
My Lord, this matter on the last occasion, petitioner and private respondents, we have filed written arguments.
Oh yes, Mr. Sulais.
Lordship, yes, I'm submitting. One copy.
My Lord, on the last occasion, private respondents had also filed their written arguments. Having gone through, my Lord, we see that a certain argument has been raised, which was in the written arguments, which was not really raised in the oral arguments. If Lordship allows, my Lord, we'll file a small additional written submission against that small point. That
when you will file it, so Mr. General, the problem will be that.
My Lord.
Vacation is
coming up.
Coming up.
No, it's ready, my Lord. We can file it right now.
You have a, can you file it now?
It's ready, my Lord. I'll file it right now.
Yes, any objection? If you file
Very
it?
small.
Your Lordship, in that case, we would also like to file an additional written argument, Your Lordship.
No, that is, the problem is that, see, like what you take, they should get a chance to say.
No,
Give us a copy.
My Lord, it's this way. On the last occasion, they filed the written arguments. We went through it. We took the trouble of going through it. We saw that one point was there, which was not really argued during the oral hearing. So we've taken the pain of preparing it today for filing. Now, what further written argument do they want to file, my Lord? Because
see, like
this is a reply to their point.
This court thought that the hearing will be concluded today. Will reserve it for judgment.
Appreciate that, my Lord. Appreciate.
Now, if you are filing
written
something today, then at least they should get a chance to see it. That is the main.
I know what is.
This is a reply to their point, my Lord. It's a very small point that they've raised.
But then they should know it. They should know.
I'm giving a copy.
Whether it's a really reply or it's an additional point, that is for them to say.
My Lord,
they have a right to say it. Isn't
my
it?
Lord, what they've done is they've raised a point that, according to them, the advertisement, in 2010, there were 40 posts available. Again, according to them, these 40 posts were advertised in the advertisement. And according to them, 40 persons being employed, being selected in 2010 means the merit list
goes exhausted.
Gets
so
exhausted.
That is what Mr. Momin had submitted that
Yes,
point
my
of time.
Yes, my Lord. So if Lordship allows, just on that point, my Lord.
No, we can allow you. The thing is that provided they should, cannot deprive them also of a chance.
No, this is a reply to their point. It's not a fresh point that I am raising, my Lord. It's a reply to the point that they have raised, my Lord. It's not a fresh point from my side. It's a reply to their point, my Lord.
Anyway, you do one thing. We will not close it. We are not closing it. This matter, we will have it next week again. In the meanwhile, you go through the thing.
Right.
There's no other option. Now your response, if it's so many pages, then what is your main argument? How many pages? It is thicker than repetition.
No, little. It's the nature of the case, my Lord. So many arguments were raised.
That case probably. Anyway, you see.
I think that is not the issue.
This is part of the
Not the issue.
Do we have anything to do with this contempt?
My lord,
Okay, since they have raised, so you need to respond.
my lord, that is the only reason, my lord. Actually, if
May not be.
it's not a point that lordship gave too much importance to. I appreciate that, but because it is part of their written arguments, we do not want to leave any point not addressed, my lord. It was raised during the oral arguments, but my lord was not very.
Can you reserve it? Can you close it or?
Because
No, Your Lordship, we'll go through and just.
Okay, just say.
Come next week, then you'll answer.
That is what the court is. The thing is that we do not know. In such a case, the judgment also will be delayed. You see, that is a problem. And the holiday is one thing.
My lord.
Spoils us actually.
It spoils everyone, my lord. It spoils the entire flow of things.
Just say, let's say Mr. Andy Fly, learned AG has submitted his written notes of argument. Stop. Mr. Jindal, learned counsel, has submitted an additional written argument on behalf of the original written argument on behalf of the petitioner. Stop. The counsel appealing for the respondents. Sorry. That they have been supplied with a copy of the additional written argument of the petitioner only in the courtroom today and would require some time to go through the same. In view of the submission, list this matter in the next week. Do not know what we'll do. Yes. It will come up next week. My lord.
Online.
It's connected.
15 to 24. Same order. 15 to 24.
This same order will be.
Same order.
Yes,
We are passing common order.
Yeah, common order.
What we
Item
say
number
here?
26.
One second. Just what you said? Okay.
Offline.
Item number 26.